All right, this evening I'd like to share with you Anita Allen's piece discussing the constitutional law and privacy. So I'd like to begin this lecture by reminding you of something that we studied previously. We learned about the difference between valid and sound arguments. Now, validity and soundness were good-making features of arguments. They were ways that arguments could be good. And just to quickly remind you, though I'm sure you remember, a valid argument is an argument in which there is a very special relationship between the premises and the conclusion, in which the premises guarantee the truth of the conclusion. Put a little bit more formally, the premises could not be true and the conclusion be false, or if the premises are true, then the conclusion must be true as well. When we talk about things like this, we're talking about logical validity. Now, a sound argument, in contrast, is a special kind of valid argument. It's a special kind of valid argument because all of the premises therein are true. Remember that a valid argument could have silly premises, things like all men are mortal, and Socrates is a man, and Socrates is a carrot, so Socrates is a man, mortal, a man, and a carrot, things of that nature. Didn't quite state it right, but you get the picture. Valid arguments can say some pretty silly things, and you know what? Validity comes cheap. But what's hard to do in logic is to find an argument that has true premises and has that special relationship between the premises and the conclusion, in which the premises guarantee the conclusion. So those were two good-making features of arguments that we already learned about in this course. Now let's complicate things just a bit. I want you to consider the following argument. Premise 1 here says it's good for you to eat organic stuff. Premise 2 says these cherries are organic. And so conclusion, it'd be good for you to eat these cherries. To me, this seems perfectly acceptable. I like this term organic. I like organic cherries. I've never met someone, by the way, who thought that organic food was bad for you. I've met people who have expressed doubt that there are actually some sort of health benefits associated with eating organic stuff, but I've never met someone who thought that eating organic stuff itself would be bad for you, right? So hopefully this argument is somewhat uncontroversial, but at least maybe you'll grant that it's valid, has a nice relationship between the premises and the conclusion, where if the premises are true, the conclusion must be true as well. But now that we have this idea of a good type of argument at play, let's consider something that looks bad, looks worrying. It might seem valid, but is actually wrong, misled, or defective in some way. So here's premise 1. It's good for you to eat organic stuff. Premise 2. This potting soil is organic. So our conclusion is, it's good for you to eat this potting soil. Now, what's gone wrong here? Well, arguably, what's happened is that the term organic is being used in different ways in different contexts. And there is a specific logical fallacy associated with this kind of reasoning. To pull up the argument again, we see here that when somebody talks about eating organic stuff, they likely are using the term organic to mean something like food that's grown free of commercially manufactured pesticides or something like that. But when we talk about potting soil being organic, we're not talking about the potting soil being free of manufacturing in a way that avoids commercial pesticides. Instead, organic potting soil is usually potting soil that comes from organisms. There are worm casings or guano or something like that in the potting soil. And so organic can have two different senses. In one sense, it means grown free of pesticides. In another sense, it just means the product of an organism, a living thing. So perhaps we look here at the good argument and note that this argument will strike us as good because we think of the term organic here as just meaning grown free of commercially manufactured pesticides. But in the bad case, we think of this argument as inappropriate or defective because organic in the premise 1 is being used differently than it is in the second premise. And so I'd like to tell you about the logical fallacy of equivocation. Equivocation happens when a single term is either used differently in two or more of the premises, or is used differently in the conclusion as it is in a premise. So here it just looks like the term organic figures only in premises, but if you had a conclusion that had the term organic in it, an equivocation might infect the conclusion as well, right? So there are two different ways you can commit this logical fallacy. Now, why are we going to be talking about this? Well, in the piece that you've read for today, Anita Allen discusses and explicates the concept of privacy. And we've learned that privacy could be used in a multiplicity of different ways. We already had reason for thinking this, didn't we? We saw that in South Staffordshire Water Company versus Sharman, the pool, Minster Pool in particular, was considered to be private by the English courts. And why was it considered private? Well, private in the context of Finder's law just meant that the owner had manifested a certain intention of keeping out the riffraff, keeping out the unwanted parties from being present at Minster Pool. When an owner manifests a certain kind of intention to exclude other parties, the locus, as we learned, is considered private. But that's different from other ways that we've used the term private before in our ordinary language, isn't it? You might think about the way in which an electric company might be private. What does it mean for an electric cooperative or company to be private? Well, it means that it's owned by people other than the government, right? Also, there might be private events at restaurants, which not just anybody can come to those events. A private event at a restaurant presupposes that if you're allowed to be there, you have some kind of invitation or something like that. So it was pretty obvious, I think, to you, hopefully, that private as a term could be used in different ways. But Anita Allen will describe for us a few different senses of the term privacy. There are three senses with which we'll be primarily concerned in this lecture. The first of these senses is an informational privacy. This is a right one enjoys in which one may not access certain information about a person. So if my medical record is private, you may not access it. Likewise, my credit card information, social security number, and things of that sort. I have a certain right of privacy in those things where you have restricted access. You cannot see this information about me, can you? The second sense of privacy that Anita Allen explicates is this sense of physical privacy. It's hard to say exactly what this is, but I've done my best. Physical privacy is a right one enjoys in which one may not commit unwanted touching of a person's body, nor occupy certain spaces around that person's body, or perhaps use machines also to do that. So I have a right to privacy when I'm taking a shower. I also have a right to privacy in my home, meaning that you can't just show up to my house and expect to occupy the space around me. And you can't touch me without my consent either. I have this right to privacy in my own body. Now, lastly, we have this notion of decisional privacy, which Anita Allen describes as a right to make certain decisions about matters that you wouldn't want widely disseminated. In other words, they're deeply personal decisions, and you don't want outside interference in those deeply personal decisions. Decisions perhaps about who to marry, whether to use contraception, whether to abort a child, things of that nature. These fall under the shadow of decisional privacy. Okay, so now that we've talked about three different ways in which jurists, judges, lawyers, and the constitutional law have used or appealed to this term of privacy, we might see why it has certain constitutional support. In other words, when we read the Constitution, we find out that the Constitution has much to say about privacy and that it implicates privacy in a variety of different ways. The first kind of illustration of this is going to be the First Amendment. Now, in the First Amendment, I have to confess that over the years that I've been teaching this course, I've always felt a little bit reluctant to say that the First Amendment implicates privacy. Let me tell you what the argument is, and you can settle the issue for yourself. Don't let me infect you. Don't let me do it for you. But basically, as you can see here, the First Amendment guarantees the right of people to peaceably assemble. Now, because sometimes a government might shut down a peaceful assembly, it's often thought that some organizations have a right to keep information about their member lists private. Okay? So the First Amendment is thought to implicate privacy because if the government knew who was a member of a certain organization, and the reading mentions the NAACP explicitly as a famous case in which this happened, the organization might be less inclined to meet if their member lists were known about. So something about the right to an information in and keeping that information private facilitates free exercise of this right of peaceful assembly. Seems plausible enough to me, actually, although you wouldn't have thought it just by reading the text of the First Amendment, I don't think. So in this way, the First Amendment is thought to implicate privacy, and more specifically, the First Amendment is thought to implicate informational privacy. When we think back to the three kinds of privacy, physical privacy, informational privacy, and decisional privacy, it seems most obviously connected to me to this notion of informational privacy, a right to restrict an outside party's access to information of some sort, right? Let's continue on with the constitutional support that we have for privacy. Here we have the Third Amendment. The Third Amendment explicitly states that no soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Now here, unlike the First Amendment, the Third Amendment is not concerned with informational privacy. Instead, the Third Amendment is concerned with physical privacy. It's concerned with one's person and the space around one's person. And one's home is a paradigmatic place in which one enjoys the right of privacy, isn't it? It's one's castle, according to the common law. It's one's sanctum. And the Third Amendment guarantees one's right of privacy, physical privacy more specifically, in one's home during a time of war. And so I think there's a plausible enough story to be told that the Constitution is concerned with privacy because of the Third Amendment, which guarantees physical privacy. Anita Allen continues on to talk about the Fourth Amendment. She talks about the right of people to be secure in their persons, houses, papers, and effects. I wasn't immediately sure what an effect was, but it just seems to me to be personal property, maybe a car, maybe a computer, something of that sort. Now, it's not entirely clear to me what the government would be trying to do if they looked at my computer or my car, but I suspect that what they'd be trying to get is not access to me, but rather information about me. And so here, when the Fourth Amendment protects one and their ability to be secure against unreasonable searches and seizures and their effects, I think the Constitution is protecting informational privacy. The question is easier when we consider one's papers. Papers usually contain information about someone. And so here in the Fourth Amendment, it looks like the Constitution is protecting, again, informational privacy. But here we have also a right of people to be secure in their persons and houses. And this doesn't seem to be informational privacy anymore, does it? It seems to be physical privacy. And so the Fourth Amendment seems to be concerned with both informational and physical privacy. The Fifth Amendment itself contains this clause. Someone can't be compelled in a criminal case to be a witness against themselves. You can't be compelled to give up incriminating information against yourself in a court of law. In other words, you have a right to restrict access to information about you. And so it looks like the Fifth Amendment might plausibly be concerned with privacy as well. Again, in the informational sense. It doesn't deal with privacy in your person. It does deal with privacy and information about you and the crimes you may or may not have committed. Okay. One thing you might be thinking at this point is that it's very odd what's just happened. How have I proceeded in this lecture so far? I've described for you three different senses of privacy. I've described for you informational privacy, decisional privacy, and physical privacy. And yet, when we look through the text of the Constitution, what do we see? Well, we've seen some pretty plausible support for the idea that the Constitution protects physical and informational privacy. But there's an awkward wheel dangling in the air that's not really connecting to the ground in any meaningful way. It's this idea of decisional privacy. So how might the Constitution be thought to support decisional privacy? Now, if you were perhaps more up on your Constitution, you might have a quick answer at hand, or you might be more prepared to answer the question. And so the question might not even seem obviously settleable for you. But I think it's a real puzzle because decisional privacy seems to be quite unlike the other two things in the set of things that we call privacy. So what are we going to do with this notion of decisional privacy in which one has a certain right to make decisions free of unwanted intervention and intrusion from outside parties? Let's try to amplify the problem just a little bit by thinking about an argument that may or may not be problematic. Consider premise 1. The Constitution protects privacy. Premise 2. Some matters related to the use of contraception are private. Okay. Conclusion. Therefore, the state protects the ability of one to use contraception, and a state may not prohibit the use of contraception. Okay. Well, I can definitely think of ways in which the use of contraception is private. After all, one doesn't have a right to know about whether one is using contraception. It doesn't seem to me. I have no right to know whether somebody else is using contraception or not. And I have no right to kind of look through their drawers to see if I can find evidence of it. That would be absurd. But so far, I've just been talking about privacy in physical and informational senses. The conclusion of this argument that I have on the board involves privacy in a decisional sense, a certain kind of ability to make decisions about the use of contraception free of unwanted intervention, intrusion, and prohibition from outside parties, right? So how do we get there from the Constitution? One is true, it seems to me, because of the decisional and informational senses of privacy we've just seen in the Constitution. Two would be true in an informational sense, but it's clear when we get to the conclusion that we're no longer talking about an informational or physical sense of the term privacy. What we're really talking about is this third sense of privacy altogether. So one of the things to come out of the Anita Allen article, a worry that needs to be raised and a worry that needs to be settled and a worry that we'll be thinking about in the coming weeks, is whether arguments like these are equivocal, whether they contain equivocations, whether they're logically fallacious, and whether it's bad to make arguments that look like this. Now, we have a second worry for this notion of decisional privacy that arises from the Anita Allen piece. The second worry that arises is that when we talk about decisional privacy, all we're talking about is this ability to make decisions free of unwanted intrusion and intervention from outside parties, right? What does that sound like? It sounds like the all too familiar concept of liberty or freedom, doesn't it? Decisional privacy, it might turn out, is nothing more than freedom or liberty under a different name. To drive this point home, think about a teenager who wants to stay out quite late, but their parents don't want them to do so. Suppose the parents call the teenager and they say, "You got to be home by 10 o'clock. Man, I hated getting that message when I was growing up. Maybe you did too." The parent says, "You have to be home by 10. I want to stay out till 12. But I would never, no matter how badly I wanted to stay out till 12, object to the idea that I had to come home at 10 o'clock on the basis that it infringed in some way on my privacy," right? Really what I wanted in that context was not the ability to shield certain information about myself, though I might have in other contexts. What I really wanted in that context was a liberty, a freedom to make a decision to stay out till 12, free of unwanted intervention from my parents, right? So it's not that in that context of wanting to stay out till 12 midnight that I lacked decisional privacy. Really, I just lacked the freedom. Consider also, just to drive this point home, maybe two people go out on a date for the first time, and when the waiter comes, one person orders for the other person in a way that's completely unwanted. Oh, I'll have the steak and she'll have the salad. Now, the person for whom the food was ordered might not object to that behavior on the grounds that it infringed on their privacy. But that's exactly what we would expect to happen if decisional privacy was a real kind of privacy, wouldn't it? I don't think that's plausible. I don't think you'd be sitting at the date, someone else having ordered your food, and then say, oh, you've just infringed on my privacy. You might say, what the heck? I had the liberty or the freedom, or I get to order my own food. I have the right. I have the ability. I have the freedom, right? And so it seems there that really this notion of decisional privacy is just reducible to other familiar notions of liberty and freedom, right? So we have two basic challenges for decisional privacy that we'll have to think about in the coming weeks. The first kind of challenge is that how do we appeal to the Constitution to establish the idea that the Constitution guarantees a kind of decisional privacy? After all we've seen throughout the Constitution is that it guarantees various forms of informational and decisional privacy. I mean, informational and physical privacy. The First Amendment guaranteed a kind of, perhaps, informational privacy to member lists. The Third Amendment guaranteed a kind of physical privacy in one's home. The Fourth Amendment likewise guaranteed these informational and physical senses of privacy in one's person, papers, houses, effects, and things. And the Fifth Amendment guaranteed one a kind of security and information about whether they've committed crimes, right? In all those cases that I've just talked about, what we've seen is the Constitution implying or implicating in some way a physical or informational privacy. We never thought about those clauses of the Constitution as guaranteeing a right to make decisions free from unwanted access. So two puzzles. The first puzzle is, how do physical and informational senses of privacy generate a decisional right of privacy? The second challenge to decisional privacy is, isn't this just liberty? Isn't it just freedom? Why do we need a new term for liberty and freedom? We already have these familiar concepts, and we appeal to them all the time. So those are two kinds of challenges. Now, I think one way you might think about this in the Allen piece, she cites, by the way, Ruth Gaveston, a rather well-known legal jurist and philosopher. But to me, it seems like Allen cites Gaveston somewhat favorably, although it's not clear to me whether Gaveston completely expresses a view with which Allen will agree. We'll think about that later in the semester when we read a second piece from Anita Allen, in which she discusses abortion rights that might be grounded in equal protection. But for now, what you might think of Allen, and I think Gaveston is doing, is inviting the real privacy to stand up, right? What is the real privacy? What is privacy really? When you think about the term privacy, what kind of stuff, what kind of cases are picked out by that term? Now, one philosophical strategy for defining what privacy is to appeal to the idea of restricted access. Whatever privacy is, it involves some kind of restriction of access to something else. You might think that this has good explanatory power when we think about physical and informational privacy. Why would you think that? Well, with physical privacy, you might think that what one enjoys the right to when one has physical privacy is a certain right to restrict others' access to one's person. Likewise, in the case of informational privacy, one has this right to restrict others' access to information about them. So in both cases of informational and physical privacy, one enjoys these rights because one has a certain ability to rightly restrict access, the access of others to a certain place around you or information about you. But when you think about restricted access and decisional privacy, it's a lot harder to tell that story. What exactly is decisional privacy? Well, it's an ability to make decisions free of unwanted intrusion or intervention from other parties. But it's not like you're restricting other people's access to something. it's a lot harder to tell the story about how restricted access could be involved with decisional privacy. I'm not saying that a smart person couldn't do it. I'm just saying it's not obvious, right? So there's kind of prima facie pushing against the idea that decisional privacy is like the other two things in the set. Suppose somebody comes along and they say, oh, there's actually three kinds of privacy guaranteed by the Constitution: physical, informational, and decisional. You can think of Allen and Gavison as saying, well, one of these things is not like the others. Decisional privacy is not like informational and physical privacy. And how do we know that decisional privacy is kind of the odd thing out? It's not characterizable in terms of restricted access. Okay, so when we think about this Allen piece, what I'd like for you to think about is this idea that the term privacy in the constitutional law is the kind of thing that stands to be or could be used equivocally. Let's keep our eyes open in the cases that we'll read for next week. And let's try to ascertain whether privacy is being used felicitously or not. That's our call to action. All right, so just to sum up, an equivocation is a kind of fallacy in which one term is used either differently across premises or it's used differently in a premise than it is in the conclusion. We saw this in the case of organic, didn't we? Soil can be organic and apples can be organic, but they're not organic in exactly the same sense. Likewise, privacy too can be used in different senses. Privacy could be informational and physical, or it could be decisional, according to the constitutional law. And the idea is, when we talk about decisional privacy, Allen and Gavison seem to suggest that we might be talking about something differently, something different altogether. And how do we know that we're talking about something different? Well, we can characterize informational and physical privacy in terms of restricted access, but it's not obvious that we can do this with decisional privacy. So we might have reason for thinking decisional privacy could be used equivocally in arguments. And so let's keep our eyes open in the coming weeks to see whether the cases we'll study do in fact use the term privacy equivocally. And this, by the way, will figure in your second writing assignment. I ask you whether the legal reasoning from Roe versus Wade contains an equivocal use of the term privacy. And I ask you to identify whether various portions of Roe versus Wade contain the idea or seem to be suggesting that privacy could be used equivocally in various contexts. So keep that in mind as we go forward. That's all I have to say about Anita Allen. And I hope to see some of you on Friday so we can discuss your writing assignments. Hope you have a good night.